On This Week in Enterprise Tech, the troll is dead. Long live the troll. Twight on the set.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Enterprise Tech is provided by CacheFly at CacheFly.com.
This is Twight, This Week in Enterprise Tech, episode 44, recorded June 3rd, 2013. Don't hate the player. This episode of This Week in Enterprise Tech is brought to you by Hover.com. Hover is the reliable domain name registration and management service that's simple, honest, and easy to use. For exceptional customer support and 10% off your new domain name, go to hover.com/enterprise and enter offer code ENTERPRISE. And by RingCentral. We do everything in the cloud. That's why I love my cloud-based phone system by RingCentral. Zero startup costs, and RingCentral is $20 per month per user. Try it now with a 30-day risk-free trial and buy one desk phone and get a second phone free up to 20 phones. Call 800-543-9980 or visit ringcentral.com and use our promo code TWIT. And by GoToMeeting with HD Faces by Citrix, a powerfully simple way to meet and collaborate with colleagues and clients from anywhere. You can share the same screen and see each other face-to-face with HD video conferencing, even from an iPad. Sign up for your 30-day free trial today. Visit GoToMeeting.com, click on the Try It Free button, and use promo code ENTERPRISE. Welcome to Twight, This Week in Enterprise Tech. It's the show dedicated to the enterprise professional, the IT pro, and the geek who just wants to know how the world is connected. I'm your host, Father Robert BALLECER, the digital Jesuit, your guide to all things in the enterprise. And as always, I'm joined by an all-star cast, starting with recurring co-host, Mr. Louis Maresca from Microsoft. Lou, thank you very much for coming back. It's always a pleasure to have you. Tell us a little bit about who you are for the people who have not seen you before and who you represent.
Sure. My name is Lou Maresca. I'm a developer, a senior developer at Microsoft. Been there for about 10 years, and I work on the Dynamics CRM team there. And, of course, I represent Microsoft in some sense, and, of course, I have my own opinions as well.
And you are one of the founding members of the Twight Riot. Now, let's go to our guests. We've got a very interesting docket of guests, those who are legal experts, starting with, of course, friend of Twight, has been on the program back in, episode 27, Mr. Evan Brown from the Info Law Group. Evan, you're not in your regular space. Where are you today?
I'm just hanging out in the Loop downtown. I teach a course on negotiations at Kent Law School down here in downtown Chicago. So normally I'm out in my office, not so centrally located in downtown Chicago, but I'm just hanging out here today. But most of all, I'm excited just to be hanging out here on Twight with you, Padre. This ought to be a really fun conversation. I'm looking forward to it.
Yeah, I was waiting for the right crowd in order to be able to discuss the following stories, which is why I'm really, really happy to have you. And the next guest, he was last on Twight, I believe, half a year ago, Mr. Dan BALLECER. Now, don't mind the last name. We're not related at all, except for maybe by blood. Dan, thank you very much for coming on from Phoenix Law. You are actually in Phoenix, right?
It is actually Phoenix, Arizona. Thank you, Padre, for having me on.
And what's your background? What do you practice? What's the thing that you do every day when you're not on Twight?
Well, I'm actually an attorney. Been licensed since 1995. Been practicing for the past 18 years or so. Practice exclusively in criminal defense and immigration. I don't do any copyright, but I do follow it on your show and on the Twit network. So we'll see if I can have anything remotely intelligent to add to this conversation today.
Dan, this is Twight. We don't do remotely intelligent. Now, with that, the die is cast. The panel is set. Let's get on to the first story, which is something I've been holding on to, Prenda Law. Now, let me give you the rundown. For the people who have not heard of Prenda Law before, this is the reason why this is probably the story of the year as far as precedent for copyright trolls. Now, it's a sad, strange story. The principals of Prenda Law were lawyers by the name of Paul Duffy, Brett Gibbs, Paul Hansmere, and John Steele. Now, they are a group of lawyers who set up two shell corporations and then acquired the rights to a few pornographic films and assigned them to those shell corporations. They monitored BitTorrents for those downloading the films that they had purchased the rights to. Then they petitioned ISPs to hand over the identities associated with those IP addresses. Now, so far, this is like any other copyright case. This is what a major label would have to do if they want to try to nail someone for copyright violation. You have to monitor the BitTorrents. You have to petition the ISPs in order to get the identities of the people who downloaded those torrents. But here's where it goes horribly, and some might say hilariously wrong. They would sue for copyright violation, but with a twist. They would offer a settlement amount that would be just below the cost of a bare-bones legal defense. And then they would do it many, many times. They would send out the suit. They would shotgun the suit. They would promise to make the copyright violations public if the defendant wanted to go to court. So in other words, if you said, no, I don't think you can get me for this, I'm going to fight this in a court of law, I will actually pay the money to clear my name. They would say, well, fine, but just so you know, we're going to put up on our website the fact that you are currently being sued for downloading busty nurses with naughty purses, stuff like that. It was a strategy that resulted in over 350 lawsuits, and get this, got them just less than $15 million in settlement. Now, Lou, let me start with you before we go to our legal experts. How much have you heard about the Prenda Law case?
I mean, it's basically just basic patent trolling, right? I mean, it's to me, it's like at the base level, it's like extortion if you think about it. I mean, they're basically finding a legal way of extorting these people and finding their low level of wanting what they want to pay for. So, like, for instance, if I were to do something that I thought nobody else thought I did, and then somebody saying, I know you did it, it's extortion at the lowest level. So I don't understand. But yeah, I've heard many instances of this.
Yeah, extortion at the lowest level. Evan, let me go to you for a second here. We've heard strategies somewhat akin to this. This is what the RIAA and the MPAA did, right? I mean, they did shotgun lawsuits where they took all the names downloading a particular title. I can think of the Hurt Locker. I can think of Metallica songs for the RIAA. And they just sued everyone. So what makes this so different? Why is this case interesting?
It's porn. I think that's probably the biggest difference between all those things. I mean, when we look at this concept of copyright trolling, what we're calling copyright trolling here, where it's a rights holder, a copyright holder going and filing lawsuits against hundreds, sometimes thousands of people, what we see is a creature that has, I mean, what this trolling activity is the embodiment of a creature that exists in a very special niche sort of ecosystem where more than one conditions are right for this kind of organism to develop. I'm thinking of, in biological metaphors, only certain types of creatures can adapt to certain environments. And now I realize that I'm talking to a Catholic priest. Maybe I shouldn't get into evolution. I don't know. But anyway, what we have here is a situation where there's a fundamental problem with the way the damages are set up under copyright law, the availability of statutory damages, which are just grossly out of proportion to any kind of actual harm that a copyright owner would suffer. If you go to court and you are a successful plaintiff, you can recover, if you can show that the defendant was willful in infringing your copyright, you can recover up to $150,000 per work, regardless of what your actual damages were. Maybe it was a $29.99 movie that was downloaded once. I mean, it doesn't happen very often, but you can just see that it's just many orders of magnitude greater than what the what the damages are. We've also got just this issue, and I'm a lawyer and I help clients, and it's how I make it's how I make a living. So I don't want to disparage this too much, but it is expensive for people to litigate cases, to defend themselves. It's expensive to pay lawyers to go and make arguments on one's behalf, and that's a reality. Whether we want to add a good value to that or a negative value to that fact. But the biggest thing here is, like I said, what makes this different than the RIAA's efforts and other motion picture studios' efforts is that this is porn. And so there's this very extremely kind of, overriding threat of embarrassment that these John Doe defendants face, saying, hey, people are going to think where there's smoke, there's fire. Even if I'm completely innocent, I don't want to be associated in a public record with even being accused of trading in pornography. We can talk about this later, but I've got some interesting stories with John Does that I have defended in situations like this, where they just had every reason not to be disclosed to the world as somebody involved with this, and I know that they had nothing to do with it. So it's the porn that what makes this really interesting, and it wouldn't be nearly as intriguing if it was something much more benign, I guess would be one way of putting it.
I like that. That's actually a great point, because that's why, remember, these plaintiffs didn't actually own any of the copyright material. They bought the rights to sue on behalf of the copyrighted material. They bought porn specifically because of the shame factor, right? I mean, if they had bought the rights to a couple of songs that had been downloaded a couple of thousand times, people wouldn't care if you posted on your website that they're being sued for downloading their songs. But they will care if, they're trying to keep up the airs, if you start posting their name and associating them with downloading pornographic material. Now, our technical director, Jason, who is a fantastic TD, I don't know how he found this while he was TDing the show, found this article from TechDirt that points to the fact that John Steele, who is one of the defendants in the Prenda Law case, actually may have uploaded some of this video to the torrent sites himself. So it was sort of a honeypot. He put it up there, knowing that people who are downloading porn are probably just taking whatever torrents they can find, and then he used that to be able to sue them. I think that's another aspect to this. Dan, I want to throw this over to you. One, what do you think about a plaintiff who is purposely uploading material to see who will download it? And why do we care that there was a two shell corporations that were set up to do this? What's the significance of having those shell corporations?
Well, I think, first of all, I totally agree on the porn aspect that differentiates this from a Hurt Locker type situation. There's certainly a lot more shame with regards to downloading porn than downloading the Hurt Locker, for example. Neither of which, of course, would be desirable for the defendants, but porn is just kind of an extra level. Our society is still somewhat puritanical in nature, so I can see how the shame comes in. But at root of the situation is, if the allegations are correct, if Judge Wright, the district judge in Los Angeles who issued the ruling with regards to a bunch of LA cases, which, by the way, was the most epic ruling I've ever read.
We'll get to that. Don't spoil it, but yeah, we'll get to it.
But in any event, if his allegations are correct, and just to be fair, all the lawyers and everybody associated with Prenda have all denied it, and they are appealing that order right now. But assuming that is true, even assuming it's partly true, what we have here is some extreme, in my view, attorney misconduct. I don't know exactly what ethical rule that it would necessarily fall under, but certainly, for example, setting up two shell companies to try to hide your identity and then suing. And then another story that I heard was that a process server who was serving a lawsuit had a note saying, you need to call this lawyer, he can help you. And that lawyer happened to be John Steele, I believe, who, of course, was associated with the plaintiff, and he never actually mentioned that he was representing the plaintiff firsthand. There's a pattern of deception here. The problem is that when you talk about lawyers, when you talk about doctors and other people who presumably have higher education, higher knowledge, and they're representing people who do not have that type of knowledge, the chances of being exploited increase exponentially. And so our state bars and our rules of ethical conduct are supposed to try to prevent that. And yes, this is about porn, but these people are, if it's true, we're engaging in some seriously deceptive behavior, and it doesn't look good for lawyers in general. It gives us all a bad rap. I think we get a bad rap anyways. But something like this is just really ugly. It's just really ugly. A lawyer, when he puts himself out, when he files a lawsuit, first of all, has to believe that he has a good faith basis to win. Okay? From what I understand, not one of these cases have ever gone to never gone to a trial. They just dismiss it if they get even the hint of some type of a defense. And this is after thousands and thousands. And then, of course, the suspicious settlement offer of $4,000 for each of these violations. And again, the ownership interest or the rights interest in the plaintiff and the lawyer, in my mind, creates an unmistakable conflict of interest, something that I just can't imagine a scenario. Again, if the allegations are proved true, that the state bars of California and then the federal bars will not have some type of consequence for those attorneys.
Right. I like the fact that you brought up the district judge, because that's actually so big a part of this case, which is his efforts to discover exactly what was going on. This case has been going on for months, and District Judge Otis D. Wright the second, basically had to decipher a shell game. You had the two shell corporations, plus there's allegations that they stole the identity of another person and had him be the signator on a lot of these cases, which made it almost impossible to trace back to the original principles. That was one of the big shocking moments when he had to issue subpoenas to everyone associated with Prenda Law just to get them in front of him, because he wasn't even sure who actually existed. That's how bad of a shell game, that's how bad of a bad faith lawsuit this actually was, where he wasn't sure if the people who were on the page were actually people or if they were just names made up by the Prenda defendants. Now, I do want to go into the happy end of Prenda Law, because it is something to behold. First of all, I have to say, Judge Wright must be a huge fan of Star Trek, because so much of his decision was couched in Star Trek folklore. Let me read you a quote here. The plaintiffs have outmaneuvered the legal system. They've discovered the nexus of antiquated copyright law, paralyzing social stigma, and unaffordable defense costs. And they exploit this anomaly by accusing individuals of illegally downloading a single pornographic video. Then they offer to settle for a sum calculated to be just below the cost of a bare-bones defense. So now, copyright laws originally designed to compensate starving artists, allowing starving attorneys in this electronic media era to plunder the citizenry. That was essentially his summary of all the discovery phase of the case. This was after he had looked through all the cases, through all the depositions, and actually had the people in front of him where he said, this is what's going on. Now let's actually bring the case to trial. And his decision quotes a few things. Let's see. The needs of the many outweigh the needs of the few are just one of many Star Trek zingers. And he then decided that they would be dinged for the attorney's fees and costs for a total of just $81,000. That was for a single defendant. And in his decision, Judge Wright wrote that figure was just below the cost of a bare bones appeal of his decision. So again, a little bit of a bite back. And all the defendants were referred to their state agencies for disbarment. I want to throw this over to you first, Lou. When you start hearing about a judge who is obviously having fun in his decision, is obviously trying to hammer home the fact that this case needs to be blown into the media in order for people to understand what's going to happen to you if you start being a copyright troll, what's the first thing that comes to your mind? As a consumer, as someone who lives on the internet, what do you think? Is this a good judge, a bad judge? Is this a judge you want to see in future copyright cases?
When somebody takes that amount of passion in a case, I mean, this is the type of judge that you do want in most cases, because those are the ones that are going to dig into and figure out what the heck's going on, especially from these crazy, the kind of deceptive behavior these guys were trying to do, with these shell corporations and these aliases. I mean, it makes sense, that some of these other lawyers would have done some kind of research into this, but this guy, went another step further and went on beyond that. And those are the types of guys you want around that. I mean, these guys were these defendants and these prosecutors. They were basically bullying these people into getting their way. And this guy took a step on. He said, "I'm gonna try to defend them myself." And I would want that kind of judge for me at least.
Yeah, at least he's very entertaining. Dan, let me throw to you first. So here's a quick question. Aside from the fact that he's awarded some damages, the court costs, plus I believe they were dinged a further $150,000 as a penalty. What does it mean that they've been referred to get disbarred? Can you talk a little bit about, we've heard about the bar before. We know that people need to be verified or certified by their bar, but what does it mean to be certified? And then what does it mean to be disbarred? What does that do to an actual person who's practicing law?
Well, it causes you not to be able to practice law, at least certainly not legally. The the fact of the matter is you can be a practicing attorney if you are properly certified. The state bars of state bars are essentially the attorney equivalent of internal affairs with police departments. They get a hard time from other lawyers because it does seem like they do seem to kind of go after what look like just kind of minor type of violations, like for example with trust accounts, which is a whole nother discussion altogether. But with this type of case, it is a veritable law school exam of racehorse type issues, where there's so many different allegations of misconduct that these bar associations or these internal affairs, attorney internal affairs departments, they really need to take their time and look into these cases very carefully, and obviously give the attorneys a right to defend themselves. Again, they are appealing Judge Wright's order, but if true, it is absolutely disgusting. It gives lawyers a bad name. It really does. It makes us look like we all are just a bunch of money hungry pigs, and we very well might be, but we all have to make a living. But we do not take advantage of people who cannot defend themselves. We do not do that.
Quick question from the chat room. Sorry about this. We've got a couple of people who are asking just some of the nitty gritty of a bar. I know that you need to take the bar in every state in which you hope to practice law. If you get disbarred in one state, that doesn't mean you're disbarred in another state, right? You have to be disbarred in every state.
I don't believe it does automatically, but I think it's a pretty strong referral for disbarment in whatever state. But like, for example, with me, I'm only licensed in Arizona, but I practice all over because I practice immigration. And so I can go to immigration court, for example, in California, Louisiana, Nevada, because it's more of a federal thing as opposed to state. But if I was going to practice in California criminal or Superior Court, for example, I'd have to be licensed there for that. But I believe there is a reciprocity of disbarment, and it's a pretty good guarantee that if you're disbarred in one state, that's going to be effective on the other state too. But there'll have to be a separate order on that from that particular bar.
Evan, I want to throw over to you. What is this? And this phrase has been tossed around a few times by Judge Wright. Moral turpitude. Is that an actual legal term? Does that trigger disbarment? What are we talking about?
Well, to tack on to what Dan was saying, those are all good observations about that. Moral turpitude is kind of one of those antiquated terms, maybe not necessarily in a bad way, but just it really evokes kind of an old school kind of system way of thinking about these things. And that can be one of the grounds for an attorney being disbarred. And by its very nature, that term is kind of open, not very well defined, but somebody who has a certain amount of moral turpitude. You don't want them holding a position of public trust like what an attorney does, because when an attorney is appearing before a court, they're referred to as an officer of the court. There's a certain fiduciary duty that they owe to the client, and a certain duty of candor, honesty and uprightness that it owes to the judge. If we want to get really grandiose about it, we can point to how that role and that obligation that an attorney has, it really affects the whole integrity of our society and our civilized way of life. So yeah, moral turpitude is a term that Judge Wright used. He said he found that these lawyers, John Steele and others, exhibited a certain amount of moral turpitude that was not befitting them. It is important to note that we're talking about disbarment here and other sanctions from the different state regulatory bodies, whether that be the Bar Association or the Registration Commission or whatever. For example, John Steele and Paul Duffy are registered or are licensed to practice here in Illinois. So we are, as am I, we're subject to the rules and regulations and the requirements of the IARDC, the Attorney Registration and Disciplinary Commission. It's important to note that they haven't been disbarred. It's just been turned over, and that's a separate process of investigation. One of the things we haven't mentioned so far, I don't think, is that when Steele and others appeared before Judge Wright, Judge Wright, hailed everybody in, said, "Hey, show up and answer some questions." The first time he did that, a lot of them just didn't bother showing up. The second time, he said, "You really better be here." So they showed up, and then they took the Fifth Amendment. And as you know, the Fifth Amendment is that constitutional right that, among other things, protects criminal defendants from incriminating themselves, making statements to incriminate themselves. And so the second time they showed up, they took the Fifth Amendment, saying, we don't want to talk about this here. So Judge Wright really is operating on a somewhat limited set of facts when he made these determinations. We don't have anything straight from the horse's mouths on this, but the attorney, the ARDC here in Illinois, will likely have a greater power of getting into some facts if it chooses to actually investigate these things, because it can make certain findings that depend on, or that would lead to determining whether these guys get to keep their law licenses. So it'd be a kind of different set of investigations. One other point, just to also add to what Dan said, it generally is reciprocal when an attorney is disbarred in one state, he or she is usually disbarred in another. I know that actually happened to Bill Clinton. I think it was in the early part of the last decade. I think it was after he was out of office. He was disbarred. I forget exactly how it worked out. I think he may have been disbarred from Arkansas. He lost his law license in Arkansas, and then so he also had the right to practice before the Supreme Court, and that was also taken away just because he was disbarred in another jurisdiction. So that it is very common for for a lawyer to lose his or her right to practice law in one jurisdiction and other jurisdictions to come to the same conclusion very, very quickly. So moral turpitude is something that I guess we all should try to avoid. And isn't it ironic that lawyers for porn companies are accused of that? Take it for what it's worth.
I try to stay away from moral turpitude myself. One last question for our legal experts before we have to move on. I mean, I could spend all day talking about Prenda, but we're not gonna. And that is, whenever we have a case like this, be it copyright, patent troll, whatever it's going to be, and you have finally someone standing up, fighting and winning, and basically saying either the copyright claims are wrong, the patent claims are wrong, or in this case, having a judge say this entire empire is illegal, that you can't do this. What about the people who have already settled? What about the companies who have already paid licensing fees? If a patent is overturned, if a copyright is made invalid, can they get their money back, or because they settled, does that mean that's it, that's done? They can never look at that money again. Open question.
Go ahead, Evan.
This is, I think it's pretty unlikely they'd get their money back. I mean, you would have to go. I guess if I were tasked to represent a client who wanted to do that, I would evaluate, analyze this issue as to whether or not they could undo the settlement agreement, rescind the contract would be the legal way of the legalese way of characterizing that. And generally, to do that, you'd have to show that it was procured by fraud in the factum or fraud in the inducement. I don't want to get into any of that legalese really here, but I think you would have a hard time showing that the fraud that would have allegedly been committed by the plaintiff's lawyers in this went to the agreement in such a way that the agreement should be rescinded. Most people go into these agreements signing them with their eyes open, at least as to what the allegations are. You know what's at stake. You know what the risks are. You would actually have to go in and show that, for example, they didn't own the copyrights. Maybe there were assertions being made that actually go to the merits. So you'd probably end up having a little mini trial on some of the issues that were alleged to begin with, whether or not there was copyright infringement. And so you can see already that if most of these John Does are settling for 4 figures, that amount is greatly going to be exceeded in these efforts of trying to rescind it. And I think it'd be probably a not really strong case to begin with. So I don't think anybody should be getting real excited thinking that they're going to see a big paycheck if they sent a check to Prenda Law in the past. I wouldn't get too excited about it. But maybe, Dan, you see a different angle on this.
No, I too am pretty skeptical that they'll be able to collect any money. I mean, I suppose it depends on when the settlement happened. Perhaps they're within the time limits to set aside the settlement, I suppose. But the problem, this comes into the sort of the small minority, I believe, of cases where even if it's later discovered that the plaintiff's lawsuit was ill-founded, there is still a judicial interest in finality of judgments. Otherwise, we could be relitigating cases ad infinitum. And so I think that because of that strong interest in judicial finality, I'm just very skeptical that they can get any of their money back.
Yeah, so I think
if they, I suppose one potential remedy for them is perhaps to petition to the State Bar of Illinois or their disciplinary committee. Sometimes restitution can be made there, but again, I'm very skeptical on that.
I think the moral of the story here is that money is gone. It's been spent. It's been wasted. It's been frittered away. But now we get to move on. Now, right after the break, we're going to be talking about how this Prenda copyright troll case actually is a really good allegory for all the troll case, be it copyright, patent, whatever it might be. Now, we'll get right there. But first, I'd like to take just a moment to talk about our first sponsor. That's hover.com. Now, are you looking for an honest, reliable domain registration and management service that is easy to use? If so, well, man, you gotta check out Hover. Now, Hover makes it easy. Hover believes that everybody should be able to take control of their online identity with their own domain name, and they make it easy for you to do so. Hover takes all the hassle out of owning and managing domain names with smart, easy-to-use, friction-free, and powerful domain name management tools. Hover is all about honesty. They don't believe in heavy-handed upselling or aggressive cross-selling, and they don't believe in hiding functionality or requiring extra payments for things that should be included with your domain name management. Things like whois privacy, subdomains, and URL forwarding, things that other companies charge for, Hover throws in because they know it should be part of your basic package. Now, Hover keeps it real. They only offer services that enhance the domain name experience. They only ever partner with companies that they believe will offer their customers value and whose customers first value the things that mirror Hover's own values. Hover Email makes it easy and affordable to create a memorable email address and eschew the impersonal free webmail email addresses that so many people use today. Hover also offers choice. They offer 23 top-level domains like the popular .com, .net, and .org, as well as .tv, .pro, .mobi, .biz. Hover also offers the most popular country code TLDs like .ca, .asia, .us, and .uk. Many .com addresses are not available these days, so Hover offers you the .net address that you want. There are a lot of unused .whatever choices out there and more coming, but .net is really the one alternative to .com that everyone recognizes and accepts. In fact, it's the one that I use. Now, Hover is here to help you for the long haul, and that's important for people who really want to create a site that's going to be around longer than just a year or so. They offer excellent online help, support documentation, and tutorials covering everything from moving domain names to Hover, setting up redirects and domain forwards, pointing DNS to the most popular web hosting services, and much, much more. Hover also offers no hold, no wait, and no transfer phone support. You're not going to be bumped around from corner to corner of the company. You call 1-866-731-6556 Monday to Friday, 8 a.m. to 8 p.m. Eastern Standard, and you'll be speaking to a live person who is empowered and eager to help. Finally, Hover is a part of Tucows, a company that has been around since 1994 and that is one of the largest domain name registrars in the world. So here's what I want you to do. Visit Hover today at hover.com/enterprise. To register your domain name, use our offer code ENTERPRISE and get 10% off. That's hover.com/enterprise. And we thank Hover for their support of This Week in Enterprise Tech. Now let's get right back to it. We've been talking about a copyright troll, which is a very specific type of legal case. It's those who are using copyright law in order to shotgun a bunch of lawsuits and hopefully get a bunch of settlements. But that same strategy is perfectly applicable to those who are doing the same for patent law. Let me throw this over to you first. Lou, do you really distinguish between the legal trolls who are going after copyright and the legal trolls going after, say, patent violations?
No, they're both looking for the easy patent or the easy copyright thing that basically allows them to attack a person in a way that they can win. And it doesn't matter if it's copyright material, if it's some patent of an invention or discovery that they found.
Yeah. Dan, let me ask you this. What are the real similarities between copyright trolls and patent trolls?
Well, I mean, I think at least insofar as the internet community defines it, these are people who don't actually produce something. Maybe they purchase some patents or copyrights, or maybe they acquire a small interest in it, and then they sue. In a way, and I know this is going to go against the grain of certainly this particular show, and I'm sure pretty much all your viewers, but trolls, as much as I don't like trolls, and certainly if Prenda was doing what they were doing, they were clearly trolls. The problem is it's one of those don't hate the player, hate the game. It's set up this way. And so what's broken is the law, and that needs to change.
I love that. I love that. That's perfect. Thank you. Thank you so very much for saying that, because it's so easy to demonize these things because, well, we don't like them. We hate it when people are using the law against, what is an honest person or an innocent person or an innocent entity, or at least an entity that shouldn't be treated as trolls treat them. However, as you mentioned, this is how the system works. People wouldn't be doing this if it wasn't possible for them to do it within the limits of the law. So Evan, let me. Oh, go, no, I'm sorry, Dan, go.
I was just going to say, I would imagine that somewhere there's a copyright holder or a patent holder who probably is very, who's struggling for money, who wants some type of a paycheck, and will accept a paycheck from a troll just so that he can finally feed his family, maybe pay the rent. And so, I mean, I think there's another side to this. While I definitely dislike the results oftentimes with regards to these situations, since it in my opinion, definitely stifles innovation, they're allowed to do it. So, it's kind of hard to at least legally demonize them as opposed to just personally demonizing them.
Right. Evan, let me throw over to you. Dan brings up a great point, and that is, look, this is actually legal. For most of these quote-unquote trolls, there's nothing legally wrong with what they're doing. They're within the rights if they actually have the rights to whatever they're suing for, be it copyright or a patent, to protect that IP. That's how the law is set up. So my question to you is, how do we actually spot trolls? What are the distinguishing characteristics of what makes a troll, be it for copyright or for patent?
Right. Well, yeah, Dan's little saying there is useful, and it actually got me thinking about Fleetwood Mac. Players only love you when they're playing. So now I've got Stevie Nicks going through my mind. Thank you very much. So it's, I think there are some pretty obvious similarities between what we're calling copyright trolls and patent trolls. There's some other softer names for patent trolls, non-practicing entities, or PAEs, patent assertion entities, other ways of talking about them. So, the obvious similarities are, these are holders of rights and intellectual property who, before filing the lawsuit, weren't doing a whole lot to exploit those rights in a meaningful way in commerce. That's one similarity. The other similarity is we all hate them. We go to Tech Dirt, for example, and kind of get all frothy and think, this is such a scourge on innovation and all that stuff. So there's similarities there. But I do think there are some important distinctions, and these distinctions are helpful in kind of fleshing out this the answer to your question. What are the hallmarks of trollism? How do we spot one in the wild? In general, I think patent trolls are, for the most part, much more sophisticated actors when it comes to this. I mean, I think it's very important to note that John Steele was a divorce lawyer. He's never really practiced copyright law before engaging on a career as an attorney representing the party, doing what he did with Prenda Law. But the lawyers that I know who represent patent trolls are sophisticated intellectual property lawyers. They know what they're doing. And that is really one of the important things to note here, is that a patent infringement case is extremely complicated. There's no such thing as a simple patent infringement matter. Copyright, on the other hand, those can come and go pretty quickly. You look at the work, whether you own the copyright, you look at whether the other guy copied, and, there's liability. Sure, there are nuances, and sure, there are extremely complicated copyright cases. Just look at, the Oracle and Google case. That was a copyright case, with APIs and all that stuff. So I'm not saying that all copyright cases are simple, but there are such things as simple copyright cases. I would not say that there are such things as simple patent infringement cases. You got to go through this whole process of claim construction, seeing how these technologies are, how the claims read and whether or not there truly is infringement. And accordingly, most plaintiffs' lawyers who are patent trolls are sophisticated. And so therefore the manner of leverage is a little bit different there than what it is with copyright trolling, especially with porn. You like we were talking about at the top of the game or top of the conversation here. I guess it's a
Why
game,
do we
right?
keep coming back to porn? I don't get that.
Over on Twill, one of our mantras is always lead with porn. So that's one of our rules for that. So you can stick with it. The nature of the threat in a patent, if you're an enterprise and you get a letter from a patent troll, your concerns are different than if you get a letter for being accused of trading porn using BitTorrent. First of all, you've got to be careful in thinking about how you want to license this technology from the troll. Do you want to introduce blood into the water so that the sharks can come and eat you up? Other sharks can come and eat you up. Do you want to fight it on the merits? Because that's going to be $1 million legal bill rather than a $10,000 legal bill to your attorneys. Do you want to engage in some kind of efforts to liberate these claims from the clutches of the patent troll? Like with Newegg, some of the success that has been happening there. So I just think that patent troll litigation is, those differences are such that it really becomes a different animal because of the greater complexity that's involved in a troll being successful going after someone like that, and the licensing analysis of whether or not you want to settle is much more nuanced and clearly has very distinct business consequences on how somebody's going to decide to negotiate with a patent assertion entity.
Lou, let me throw this over to you. Let's take this a little bit away from our legal experts, and let's get down to basic enterprise people. What would you say are some characteristics of a troll?
Yeah, so basically, especially from a patent troll perspective, there's if the party purchases patents from a bankruptcy court or bankruptcy firm, the party's trying to enforce the patents without intending to manufacture the products or the services that were a part of that patent. Party sends demands to multiple parties at once, sometimes not even changing the lettering within the wording in the lettering. Even the patent violation is very vague, and it's deliberately vague, so it's very broad, so they could sue from any aspect of that. So there's many ways to kind of determine if there's a troll coming at you.
Nice. Dan, let me ask you about that. What about those simple characteristics? So the party purchases patents from a bankrupt firm. They try to enforce patents without any intention of ever actually creating product or services that will use those patents. They send multiple letters looking very much the same to multiple parties, sometimes even parties that aren't even violating those patents. And the patent violation description is deliberately vague. They make it vague so that it's difficult to actually fight back. Would you agree that those are 4 characteristics that we'll find in most patent troll lawsuits?
I agree that those are 4 characteristics that you'll find there. I would submit, though, that the first 2, the party purchases patents from a bankrupt firm, they try to enforce patents without intending to manufacture products or provide services that utilize those patents. I would still submit that, unfortunately, that's legal. And the system, as it currently stands, would serve to benefit them if they do things right. And that's when you come to 3 and 4, the whole the blast demand letter, the vague patent violation. That's when you start coming to some questionable tactics, and where Prenda Law allegedly went wrong, that they're utilizing their supposed higher knowledge of this area, and I guess they weren't even copyright attorneys to begin with, but they certainly knew more than the people they were suing, and they used their superior knowledge to exploit them, and essentially, I think the word was used earlier, to extort them. They knew call a spade a spade. If all these allegations are true, these guys were smart, and they had. It's a pretty ballsy conduct. It's not that I admire them in any way, but the problem is they're the ones, the attorneys. It should be up to the attorneys to prevent behavior like that. They should be able to evaluate each case for its merits. If they think they have a case, then proceed. If they don't, if they know that this case that I'm about to file a suit on, if it went to trial, that I would have absolutely no chance, and that then they shouldn't. I mean, it's really as simple as that. And they clearly did not think that they had a chance, or at least they knew that they were not going to, proceed directly because they never went to trial. So.
Well, it's really expensive to do that, Yeah. You got to work hard to if you can have somebody writing a check for 4 figures now rather than go through and litigate it. And you can recover your statutory damages and your attorney's fees as a successful plaintiff. But wow, what a pain in the neck it is to do that if you have people lining up to write checks to you.
Well, one of the interesting things in Judge Wright's order was his sentence about that just identifying the IP address owner and that a bit might have gone through that owner's IP is in and of itself not enough to proceed on a copyright claim. And I certainly didn't know that. And that's all they had in every single one of these cases. I don't believe they had any evidence that any of these other people actually viewed the movie or had a whole intact movie. And so that goes into whether they had the good faith basis in the beginning to file the lawsuit to begin with. It's clear that when they filed these requests for subpoenas on these IP address, it was just to extort the settlement offers. And again, if that's true, then that's despicable.
That's a sad, yeah. Now, moving into the more the patent troll than the copyright troll, here's I see the big difference. When we're talking about copyright trolling and we're talking about lawsuits sent out against individuals, the number that's been thrown around is between $5,000 and $10,000 to successfully defend yourself against a copyright troll. Now, if you're going to defend yourself against a patent troll, especially if you're a small to medium-sized business, you don't have your own law side of the corporation, the numbers are that it jumps to about $1 million or more before trial and up to $2.5 million for a complete defense. That's just bare bone defense against patent trolls. So I think even though what happens, the characteristics of trolls tend to be the same, I think where they differ from the copyright to the patent side is just the amount of money you need to be able to defend yourself. Once you get into patent trolling, because it deals with IP and it's much more complicated than copyright, you're going to spend a lot more money, and therefore they can ask for a much larger settlement. Evan, I'm sorry, were you about to say something?
No, but I'll just say word to what you just said. That's and it's to take that a step further. It's because of the sophistication involved in patent litigation. I think I was saying this earlier. I mean, you gotta, there's usually, you'll be going back to the patent office as part of the proceedings, for re-examination of the patent. Not always, but often, bringing in armies of experts to talk about this technology, rounds and rounds of discovery, motions, and I don't practice patent law, but I like to make fun of them whenever I can. And it's interesting how patent lawyers in litigation never really get to the merits; they just file motions, for stuff. And so that it's that complexity and that culture of the litigation just makes it so much more complicated and so much more expensive. So yeah, I want to close out this.
Oh, sorry. I want to close out this section with just a little story. I want to run through it. We covered this before. A Boston University study found that non-practicing entities, what you mentioned, also known as copyright trolls or patent assertion agencies, cost $29 billion in 2011. The study was authored by Professor Michael J. Muir and lecturer James Besson. Their work has been used by the FTC, the European Parliament, and the U.S. Supreme Court. Now, here's the fun thing. They found $29 billion to be the round number, up from $7 billion in 2011, but that doesn't even include the non-direct costs. So that's just lawyer time. If you included everything from the loss of production, the loss of market share, that cost jumps to $80 billion in 2011. So when we're talking about how patent trolls are, they're bad, this is one of the reasons why they're bad. They cost so much money to defend against. Now, I want to move from that into the story from the VAR guy about how Google has surrendered the future of video to patent troll MPEG-LA. Now, MPEG-LA, Danny, you mentioned this before. MPEG LA, you could think of them as a patent troll, but they actually do have a little bit of legitimacy. They are a patent pool. So what they do is they make a call for all patents, for all IP on a particular piece of technology, in this case on video. And then they, as a group, they assert those patents against large manufacturers, against companies. They're essentially saying that they're allowing the little guy who's come up with a great idea to be able to fight against these giants. But what it's being used for is being used to extort money from companies that want to use H.264. And that's basically anyone doing video today. Every camera, every video camera, every laptop, everything that has a video sensor or a video recorder is going to run afoul of these patents. Now, Google was trying to create their own technology called VP8, which would have circumvented all of the patents in H.264. Well, just yesterday, actually, a few hours ago, Google surrendered, and they've now licensed the MPEG LA technology for things like YouTube and for Talk. It's seen as a surrender in the open source community, but here's the scary thing. They did it because they realized there was no way they could win against this NPE, this patent assertion agency, the MPEG LA. And if there's no hope for Google, what hope is there for the little guy? Evan, let me throw this to you first. Google is known for fighting the good fight against patent trolls, and in this case, they gave up. That basically means it's game over, right? Everyone's going to have to license this technology.
Well, I guess. I mean, there's a lot of things we don't know here. I mean, we can speculate as to what Google's decision-making process was and all this. It had its business reasons that probably a lot of those will remain inscrutable to us here. You know, I'm always cautious to make sweeping statements like, oh, the game is over. Google has lost the internet on behalf of all of us and all of that stuff. So, you know, Google is not going to engage in, you know, some kind of legal campaign, whether it's defending itself or bringing some kind of declaratory judgment action saying that, you know, it's right and all of this stuff, unless it has the basis to do so here. So, you know, I guess I think there's a lot that we don't know about this. And, you know, because it depends on their business decisions. And plus, you know, I mean, I love the open source community. I love the concept of it. And I subscribe to all those principles. But, you know, it's pretty hard to find somebody talking about these issues without being very, very, very polarized on one side of it. So I'm trying to get an objective picture on what's actually going on here, and I just can't really do it all that well. But it doesn't sound like it's a positive development, but I don't think it's the end of the story. I think that there's got to be more to play out on all this.
There is more to play out, and we'll get right to it. But first, I do want to take some time to talk about the second supporter of the Twiat Riot, and that is longtime supporter of the show, Ring Central. Now, when Leo built the brick house not too long ago, he decided that we were going to eat our own dog food. That's right. If we were pushing people to the cloud, he wanted Twit to be in the cloud. That's why everything is done in the cloud. Our email, our documents, our scheduling, our calendar, everything is in the cloud. So when Russell, our IT guy, came to Leo and said, hey, you know, we could have a PBX without having a PBX in the basement by having it in the cloud, well, it was a no-brainer. We love Ring Central. Zero startup costs, no PBX hardware to install or maintain. Ring Central allows us to easily customize all of our call handling. Our producers get their voicemail and their emails, and we can even get our fax messages right on our smartphones. And now they have a brand new feature, Business SMS. Now you can send text messages to customers and colleagues from your business phone number. No more using your personal number to do business. That's how we know Ring Central gets us. Now, Ring Central offers all-inclusive pricing as low as $20 per month per user. You can start right now with a 30-day risk-free trial, and they have a special offer for my listeners. When you buy one desk phone, you get a second phone free up to 20 phones. So call this number designated for my listeners, 800-543-9980. That's 800-543-9980. One more time, just in case the trolls were yelling in your ears, 800-543-9980. Or you can go to ringcentral.com and use our promo code TWIT. That's ringcentral.com, promo code TWIT. And we thank Ring Central for their support of This Week in Enterprise Tech. Let's finish up with a little bit of troll stomping. That's right, we've been talking all about trolls. Copyright trolls, patent trolls. We've been talking about the despicable things that they do and why it's so bad for our economy. But now we need to talk about the ever important topic of how do we stop them? There is an interesting story from Forbes. It was basically written without the legalese of most judgments, saying there's one really, really easy way to stop copyright trolls, and that is to make them responsible for all legal fees. That's right. If you get sued by a troll and they lose or they try to drop the case after you've already invested money into the case, you should be able to be reimbursed by that company for their attempted extortion. Now, Danny, this sounds like a great idea. I would love to see this in place, but what would be the unintended consequences of making every lawsuit basically a no-win scenario for the legal firm?
Well, first of all, awarding attorney's fees to the victor is not unprecedented. It's very common in, for example, breach of contract cases and certain other types of litigation where it's built into whatever contract or agreement or whatever. So it does happen. The problem, however, with awarding attorney's fees and costs to the victorious party is it's going to create a severe disparity between those who have the money to defend and those who don't. It's going to basically place a barrier to the courthouse door for your regular mom and pop plaintiff who might want to sue, but perhaps can't get through an entire case, or perhaps doesn't have the legal sophistication, whatever. There is an interest in suing. There is an interest in litigation. And when I say an interest, I'm talking about an interest to society. Done correctly, it can make our society a better place. And so we don't want to put this artificial type of barrier in general to prevent people who otherwise might have meritorious claims from wanting to file suit. Because otherwise, there are many ways to win a case that don't necessarily involve the merits. And that's kind of the problem with having it done all over. Now, if they were going to add that to patent litigation, I suppose I wouldn't have a problem with that.
Nice. Evan, let me ask you this question. What would be the practical limits of this kind of approach to stopping patent trolls, copyright trolls? In other words, let's take an example here. Would I have to limit the amount of money I could spend on my defense? Obviously, if someone is suing me for $10,000 and then I decide to spend $10 million on my defense, I couldn't expect them to be responsible for all my legal fees, right?
Well, I mean, you've got to show. Well, first of all, let me back up and kind of frame it so we can answer that. In copyright law, the loser does pay, regardless of what side you're on. So I'm not sure what this conversation is about, saying that this would be a great idea. The Copyright Act's very clear, and there's particularly here in the Seventh Circuit in Chicago, where I practice, there's some case law that says the defendant, if the defendant wins, he is presumably entitled to recover attorney's fees from the idiot copyright plaintiff. So it's a great idea. It's the English rule as opposed to the American rule, where each side generally pays their own fees. So that's the way copyright is set up. But when you actually do this after there is a determination on summary judgment or after trial, you submit a bill of costs, and you've got to be reasonable, and the court has discretion in awarding as to the amount of what those fees are. So $10 million in legal fees. Be interesting to see who would rack that up. I mean, I would love for clients to pay me to fly around in private jets. I guess that would be one way of starting, but I don't think those people are going to be too worried about copyright, defending themselves in a copyright troll matter. But patent law is a little bit different. That's where I think the meaningful discussion could be had here, because in patent law, you're not as it's much harder to get the plaintiff to pay your attorney's fees if you are a defendant that is successful. The Patent Act requires that there be it's an exceptional case, and incidentally, that's the same kind of standard that applies in the trademark case, where if you are a winning defendant, you have to show that it was an exceptional case. And that's that's a higher standard. It's not nearly as close to automatic as what it is with copyright law, and I think it's one of those areas that could help curb patent trolling, but it may or may not, because parties like Prenda, parties like the MPAA, and just to give Lou a little bit of grief, Plaintiffs who are members of the Business Software Alliance don't seem to give a damn about filing lawsuits en masse, for these types of things. So I don't know that there's not necessarily all that much empirical evidence that would suggest that if we switch the Patent Act over to make the loser automatically pay, even if that loser is a plaintiff, that would curb trolling litigation. There's got to be more, something else to curb trolling. That in and of itself is not going to solve the problem.
Interesting. But to my two legal experts, one of the types of activities that we've seen is that a troll like Prenda will file suit, and then if it gets challenged at all, they'll drop it. But the defendant has already incurred some costs in setting up a defense, right? Can he recover those costs, or if Prenda drops it before it goes to trial, there's no recourse to try to get that money back?
You can try, but it's not as easy as it would be if they're if the judge actually made a determination on the merits, like it's summary judgment, where the parties get together and say, Judge, look, here's our evidence, and please decide that this isn't even worth going to trial. Or the moving party, like usually a defendant will come to the judge and say that right before trial, or if you get to trial and there's a fully litigated matter. When there's a determination on the merits, it's much easier to get the court to award the other side to pay your attorney's fees. That's much more difficult to do that if the law, or if the plaintiffs kind of are in and then they're out. They get all Katy Perry about it. It's much more difficult. And and it's difficult. You can try to make that argument. I have. Every time I've tried when a plaintiff has kind of pulled out early, it hasn't been successful.
All right. Now let's move on to the next bit of news, because I think this actually expands on that Forbes idea of making the trolls pay. This is a story about from VT Digger about how Vermont has now passed the very first anti-patent troll law in the nation. The bill, which was H.299, was signed into law by Governor Peter Shumlin and will take effect on July 1st, 2013. The law is actually an amendment to the Consumer Protection Law, but it now includes businesses targeted by copyright trolls or patent trolls. Now, under this law, the demand letters of a complainant must include detailed and specific information as to how the product, service, or technology infringes on existing patents. The demand letter must allow for a reasonable amount of time for the licensing fee to be paid. So no more of this, you've got a week to reply, otherwise we sue you. It actually has to give people the time they need to actually look over the complaint. The penalty for a bad faith claim is a bond equal to the cost of defending against the claim. And, this one's really important, the state AG can now file suit against patent trolls who target Vermont companies with illegitimate claims. Now, the Vermont AG has already used the law once to file a suit against MPHJ Technology Investments, which went after two Vermont companies, basically trying to extort them for $1,000 per user. Let me throw this over to you first, Lou. When you think about an anti-patent troll lawsuit and going from state to state to state, does that sound like something that corporations would be interested in, or is this mostly something directed at small companies who again, can't have their own legal departments?
I think it's more the small companies, because they're the ones that, like, even when you do like a vendor contract today, you have like a scope of work, and the reason why you define the scope of work is so that they, one, they finish that work, and one, they have basically what they're going to get paid for. And that's kind of what they're doing here, is they're saying, hey, we want a detailed, itemized list of what you're suing us for. And so that basically protects that person, so they could say, well, I didn't do any of these things. Or so they're basically itemizing it, making it more detailed. And I think it helps the consumer in some sense, but it's also going to help the corporation too, in another sense, where, maybe there is these people violating these specific things. And, you do want to give them a chance to pay the corporation for the use of those things. So, I think it's kind of a little bit both, but I think it's, again, just the small business is kind of the target for this.
Okay. Dan, let me throw over to you. I love the part of this law that talks about having a specific complaint. No more of this vague, we think you violated this patent, and this patent, and then not explaining why. Now the complainant actually has to say, your piece of technology violates this patent because. That's a big deal, right?
I mean, it is a big deal, and it's also kind of funny to me that that they actually had to write that into a law. Because, like, for example, a typical demand letter for a personal injury lawsuit was saying, okay, you owe us money because your client negligently, crashed into my client's car or something like that. or on a breach of contract demand letter, you say, you guys agreed to pay me this, you didn't, so therefore we're suing you. Give us this money, and we won't continue with the lawsuit. In other words, you say why you're suing them. You say why they are in quote unquote trouble. It cracks me up that these, I guess, patent trolls, for lack of a better term, are rewarded for being as vague as possible. It doesn't. That part just doesn't seem to make any sense to me. And so yes, I'm obviously very. That seems to be a very good thing to do, I guess, to make them include that. I would still probably argue that maybe a closer reading of the ethical rules would maybe put them into kind of a gray area as far as the individual state bars for trying to put vague demand letters out there to try to maximize the chances of settlement. I just don't understand why you wouldn't want to be specific, other than the fact that you don't have specifics to back it up.
Exactly. I think the only reason why you wouldn't be specific is you yourself are not really sure how their technology violates your patent. Evan, let me move on to you on this second part, which is the letters now must include a reasonable amount of time for the licensing fee to be paid, or for them to decide that they're going to fight the patent assertion. Why is that important?
I think it's important because it's part of the statute that will not be enforceable, because this will be preempted by federal law. I don't think the state, let me say first, I think this is a wonderful sentiment, and I think it's great that the Vermont legislature is trying to do this, and it's great that the Vermont Attorney General is trying to enforce these principles here. But patent law is exclusively federal. It's written right there in the statute. It's there's no space for any kind of patent disputes to be heard in state court anywhere. These are federal issues. So I expect there will be a ton of litigation over whether or not the state has any role in setting the ground rules or enforcing anything when it comes to all this. So that's really all that I can say about it, because it's like I said, it's great, but it's not. It doesn't make any sense to have this coming from the state. It's good. There probably is a part of it that will stay within, that may not be preempted here, and that may, still give something for the Attorney General to do. And I don't know if there's a private cause of action if citizens can file a claim under the statute or not, but obviously the Attorney General can. There's still, something other, part of it that wouldn't get preempted. Part of it that could still belong in state court is just the consumer protection aspect of it, and maybe somehow part of what we're talking about here could, if you're going after someone else and you're being dishonest, or you're being fraudulent, or not being completely, I don't know, you're doing things that attorneys general don't like you to do. Maybe there's something that is enforceable with it there that could stick around. But as far as dictating how a patent dispute should be resolved, I just don't think that the Vermont state, the state legislature in Vermont, the Attorney General, or any state legislature in any of the other 49 states has any role doing that, as unfortunate as that may be.
As iBookery in the chat room has wrote, this is so complicated, so why not just hug a dog and kick a troll? Now, we're going to wrap up with just a little bit more about defending yourself from patent trolls. But first, I want to take time to talk about the last sponsor of the Twight Riot on this episode of Twight, and that is, of course, Citrix. Now, summer is almost here, and the weather is great. The kids are getting out of school. There's so many places that you would rather be than in your office. But even though you don't want to be at work, you have to stay connected. You have to stay in communication, because that's how people work. That's how you stay in touch with your team. That's how you stay on the same page. That's how you keep productive. So we've got some great news, because with Citrix, you can escape the office and stay connected. That's right. With GoToMeeting with HD Faces, you can keep productive even while you're at the beach, even when you're on vacation, even when you're away from the office. You get to share ideas, your problems get solved, you get your projects done. It's GoToMeeting with HD Faces, the powerfully simple way to meet and collaborate online. Now, with GoToMeeting by Citrix, it just takes a click to share your screen and work on documents in real life. And with a webcam, you get to turn your online meeting into an HD video conference. You can see each other face to face. It's like meeting in person. You can easily launch or join a meeting from wherever you are, wherever you need, using your computer, your smartphone, or even your tablet. That's right, you can present from your iPad. Now, you may have noticed that I get particularly enthusiastic about GoToMeeting. Well, that's because I use it on an almost daily basis for my work and for my podcasting. You see, I'm not just a spokesman for GoToMeeting, I'm a customer. My work has me meeting with literally hundreds of coworkers and colleagues each month. Now, I used to jump in a plane every time I had a meeting because that was the accepted way of getting face-to-face time. I switched to GoToMeeting with HD Faces, and let me tell you, I haven't looked back. Not only did it cut my travel time per month in half, but it also allowed me to have more interaction with the people that I need to collaborate with the most. It saved my organization money, it saved me time, and it saved wear and tear on my sanity. I love GoToMeeting. It's so easy to use, and with HD Faces, it's really just like meeting in person. You can see that frown, you can see that nod, you can see the wrinkle in the face that says that you need to explain your idea more, and that's really what it's all about. Now, here's what I want you to do. I want you to try GoToMeeting free for 30 days. For this special offer, visit GoToMeeting.com, click on the Try It Free button, and use the promo code ENTERPRISE. Remember, use the promo code ENTERPRISE. GoToMeeting, meeting is believing, and we thank Citrix for their support of This Week in Enterprise Tech. But wait, there's more. That's right, we told you that today we would announce the winner of the GoToMeeting with HD Faces webcam contest. You had to tweet to us about who you would meet and why you would meet with the hashtags GoToMeeting. And, well, we have a winner. I'm pleased to announce that the winner of the new webcam is Paul Alves. That's right, a longtime supporter of Twit, a longtime member of the Twit Riot, and a longtime Twit listener. He shared his Enterprise and GoToMeeting hashtags to say that he wanted to meet with Stephen King. Now, for an epic book guy show, you can watch Paul Alves in HD goodness thanks to GoToMeeting. Congratulations to Paul, and remember, don't forget to try GoToMeeting today. Let's get back to it. We've got just a little bit more. We talked about the legal way to defend yourself against trolls, either trying to make them pay for the lawsuits or trying to get states involved. For various reasons, it's not necessarily the best way to do it because, as Dan mentioned, look, these people are playing within the law. It's hard to turn the law upon itself. But there is another way to do it. Lou, let me ask you about this. Have you heard about companies coming together to defend themselves against patent trolls?
Yeah, I mean, that's the way to do it, too. I mean, that each company, they basically decide on whether they're being sued by the same thing, and they kind of come together and bridge together multiple different firms and multiple different suits and bring it together and attack, back at the trolls. That's the way to do it in numbers. That's how you fight the patent trolls, is always in numbers.
Yeah. Now, this is a story from, we covered this a while back about how Red Hat defended Rackspace. They defeated a few Linux trolls. Essentially, Unilock sued Rackspace over a patent on rounding a number before instead of after an arithmetic computation. It was U.S. patent 5892697, and it was a mathematical algorithm, which the U.S. court decided was not patentable under U.S. patent law. Unilock also sued Microsoft, won a $388 million verdict, which was overturned in 1999 and settled out of court. That's actually a story we hear about a lot of these patent trolls. They settle for a lesser amount just to sort of get a war chest for future lawsuits. Now, interesting enough, Unilock brought the suit in Eastern Texas, which is known for being patent-friendly, and the case was tossed before trial. So this is all around a good way to explain how when you've got a maker of software like Red Hat standing up for a service provider like Rackspace, how you can have a chilling effect on patent trolls. If they know that they can't ever go after the small fish, but they have to fight the big players, they're probably not going to do it. Dan, let me ask you about that. Is that a viable strategy? If I surround myself with a bunch of other like-minded companies and we promise to defend each other against patent lawsuits, that makes it much more difficult for patent trolls to go after, say, the low-hanging fruit, right?
Absolutely. Earlier I was saying that that lawyers are presumably higher educated, but really, at the end of the day, what we are kids on a playground. And if you have a big, giant kid bullying a small kid, then clearly the small kid is going to be at a significant disadvantage, unless the small kid can go ahead and round up 10 or 20 buddies to help fight the bigger guy. And so, yeah, short of changing the patent law as it currently stands, it would be nice if there were more of these types of arrangements where defendants pool their resources together. I don't know if there was a formal pooling of resources in that case with Apple. It was a troll, I believe they called him a troll, who owns some type of patent on apps, third-party apps on phones, and apparently licensed it to Apple, and then sued individual app makers, saying that license only applied to Apple, not to the individual app makers. Many of those, from what I understand, those app makers pulled together, and then I think Apple finally joined into that program. Perhaps that's a way to fight it. Of course, you have to be lucky enough to have a lot of friends.
So you just have basically to fight off a bully, you need a lot of friends. Evan, let me throw this over to you with a slightly different wrinkle, and that is Google. They announced an open patent non-assertion pledge not too long ago, where they offered 10 of their patents to start with and said, if you use any of these patents or if you contribute any of these patents, we will not sue you as long as you don't sue anybody else. That seems to be another way for companies, for enterprises to protect themselves against patent trolls, which is to say, look, we want to see innovation. Here's our patents in good faith. Give us your patents in good faith. And the more people that join this pot, the stronger we become. Is that a viable way to fight off the patent troll?
I guess so. I mean, it's certainly going to work in a limited set of circumstances to the extent that there's technology that comes within the scope of these patents that are subject to these sorts of pledges or agreements, whatever you call them. I mean, there are literally tens of thousands of patents at issue in the technologies that power the things that we love working with and dealing with as enthusiasts of high technology in the second decade of the 21st century. But, sure, this can carve out a little part of that. With companies taking such, positions like this, it also reminds me of what Twitter has done with what it calls, I mean, this is kind of going in a little bit in the reverse direction, but they call it the Innovators Patent Agreement. And this is kind of establishing the relationship between Twitter and its own engineers and inventors, saying that Twitter is not going to act in an offensive way, going on the offense with these patents that the engineers are named as the inventors on and assigned to Twitter as part of their work, not going out and doing these things. So at least if we could have more people, more entities like Twitter having those sensibilities, that's going to set the tone for things like this as well. It's almost as if everybody were to do something like this, it would be kind of a worldwide disarmament when it comes to all this stuff, and you'd only leave those very rogue situations where a party needs to go in the offense, which would kind of resemble the way modern the modern military state is in the global sort of conflicts. So yeah, these sentiments are in the right direction. Little things like this, Google doing this is not going to solve the problem, but if in the aggregate there can be more like this, that's one way of skinning this cat.
Well, gentlemen, I'd love to talk forever about trolls because they are a crunchy topic. But I'm afraid that our audience has used up yet another hour listening to the best dang enterprise show in the universe. That's right, I took a poll. We came out on top. I do want to thank our panelists, starting with you, Lou. Thank you so very much for coming back on. It is always a pleasure to see you. It's always a pleasure to hear your insights. Tell us, what are the things that the Twilight Riot should know about Lou?
Yeah, so thanks again, Padre, for having me on. I actually learned quite a bit today. I was actually just listening and kind of consuming everything. But for CRM, I'm Dynamic CRM. Check it out. Coming to the device near you. We're looking for a new release soon, and coming to the web, and we should be releasing pretty soon. So getting excited, and look out for that.
And it's always a better show when we've got a Maresca. I should use that should be our slogan. Evan Brown, over to you. My goodness, you've got your own show on Twit, This Week in Law, every Friday at what time?
It is 11 Pacific, 1 o'clock Central is what I usually pay attention to. Yeah, Denise Howell and I co-host This Week in Law, always talking about interesting issues, with law and technology. So, yeah, thanks for mentioning that, Padre. Hope those of you who, aren't listeners or viewers of Twill will head on over. But, Padre, this has been awesome. I'm really, really looking forward to it. So happy to get the invitation back to talk about these things and to talk, engage with the Twiat riot. What was that? What you call that? That's what.
Twiat, yes, we are the Twiat riot. Yeah,
isn't that great?
You know what, Evan? We're trailblazers here because this is these crossover episodes. We're recognizing that within the Twitter audience, there are so many of our shows that they really do cross over into one another.
For sure. Yeah. I mean, dealing with the enterprise, I mean, there's so many issues there that, there's so many, moving parts to think about. So, yeah, the legal issues, I could see so much relevance for your audience. So wonderful to talk with you and to talk with Dan and Lou. Nice to meet you guys.
And Dan BALLECER, thank you so very, very much. Dan, tell us all about yourself. Tell us where we can find your work. I understand you also write a blog on immigration issues.
Right. Thanks, Padre, for having me on the show. This has been fun. Sorry that I couldn't bring a little bit more intelligence to the show, but hopefully I said one or two things that might have been at least remotely intelligent. But in any event, I do have a blog that I don't update as frequently as I should. It's at there in the lower third, phoenixlaw.net. I usually blog about immigration issues. It is a very dynamic area of law that changes, it seems like, on a daily basis. And so I try to keep up, perhaps try to use it also as a soapbox to try to argue for immigration reform. And we'll see what happens. But like I said in the beginning, my practice is all immigration and criminal defense. And I love my job, and I try not to take advantage of people. At least that's how I do it.
I love it. I love it. A lawyer with a conscience. Gotta love it. Now, that's not the last member of our panel. We actually have one distinguished member who he's our silent partner, and that's Mr. Jason Howell. Jason, I also understand that you have a show on the Twit Network all about Android. What's it called?
It is all about Android, and we called it all about Android because it's all about Android. So you know what you're going to get.
Wait. What's it about?
It's about Android, but it's all about it, not just kind of about it. So you can find it at twit.tv/AAA. We record live every Tuesday at 5 p.m. Pacific at live.twit.tv. Check it out.
Now, lastly, come a little closer. Yeah, I want to talk to you. You see, we do this show for you, for Chat Room, for the people who are listening, for the people who are watching right now, and we want to give you an easy way to get the show each and every single week. That's why, if you go to our show page right now at twit.tv/Twiat, you'll be able to find all the different ways that you can get our show downloaded into the device of your choice each and every single week. That's right, it's like magic. You want it in your iPod, of course, your iPhone, yeah, duh, your iPad, your Android tablet, your Android phone, your Zune, your PC, whatever it might be. We give you an easy way to select your goodness in the hotness when you want it. That's right. That should be our slogan. Also, did you know that we've got a YouTube page? That's right. If you go to youtube.com/Twiat, you'll be able to find all of our back episodes. But not only that, we have started to publish all of the little pre-recorded segments that we've had on Twiat over the last year. Stuff My IT Guy Says, The Data Closet, Pro Gear, Pro Tips. If you want to learn more about what makes engineering go, what makes the network go, what makes the engineer network go, well, drop by the Twiat YouTube page and, well, you might get learned. And learning is half the battle. Also, you can follow me on Twitter at twitter.com/PadreSJ. There you'll be able to find out what we're doing each week in every episode of Twiat. You'll be able to find out, well, what we're going to be discussing on future episodes of Twiat, and you'll be able to give me feedback about what you want to see, what you liked, what you didn't. I will respond back. That's how much I enjoy my job. Finally, you can watch the show live every Monday. You stop by noon Pacific time, and you'll be able to see how the sausage is made. All that stuff that goes on before the show and after the show that doesn't go into the download, well, if you stop by live, you'll be able to see it. And as long as you're live, why not drop in our chat room at irc.twit.tv, where you will be able to meet some of the funniest trolls, the good trolls, the trolls who make the internet worthwhile, along with some of the brightest people, the best engineers, and just an all-around great experience of what the Twit audience is. I want to thank everyone who's come here to watch, everyone who made the show possible, everyone back in the Brick House, including Jason and my super producer, Karsten. I'm Father Robert BALLECER, and remember, if you want to know what's going on in the Enterprise, just keep quiet.